With that, we officially conclude our inaugural session and we are preparing for the seminar. But right before that, we will be breaking for tea. So can we all give a huge round of applause for Radigree and Shabdin Started? We would also like to make two announcements regarding the refreshments. The refreshments are served to the right side of the venue. Adjacent to that is also the restroom facilities to my right. Also, please report back in 10 minutes. Hope to see you all active and happy for the seminar. Thank you all.
Allowance once during the year, during a calendar year. So it will not be less than second class railway fare, sleeper railway fare or bus fare, whichever is available to them to go to their native and come back. That will also be given by the employer. They'll have to have facility of availing TCS migrant workers, which already is available with the state government, which is 155214, which is even for labor online also. Then you have past liabilities. If at all you have a interstate migrant workers who has past liabilities, then at the end of his period of employment, it is deemed to have been extinguished. So you cannot claim once he quits your employment and joins somebody else, then you cannot ask for employment back. Again, plantation workers, here the definition is, earlier if you take the Plantation Act, it was mandatory for every plantation to have a group hospital or a hospital within their premises where they can give health facility to the employees. Now the facility of ESI has been extended to plantation workers. Now the plantation workers can be covered under ESI, provided the facility which is given by the employer is much better, then he can still continue with what he is giving. But the problem here with the plantation is there are few plantations wherein within the plantation, like you take a large tea plantation, there is a tea factory which is within. Now tea factory is mandatorily you have to cover under ESI. Whereas for the estate, it is under the group hospital. So that clarification again, the plantation associations have given to Government of India as to either cover everybody under ESI or cover everybody under the group hospital or garden hospital, which is maintained by the plantation. So for plantation workers, it is the responsibility of the state government to decide on the rules with respect to drinking water, housing accommodation, crash facility, educational facility in case more than 25 children are there below the age of 6 to 12 years of age, then you will have to provide educational facility, then health facility to every worker employed in plantation. Then you will have to provide recreational facilities also to the employed in plantation. So plantation, as I said, they are also, they can avail ESI facility as of now. Powers of inspector cum facilitator, nothing much has changed except for, as I said, he has to give sufficient improvement notice before taking up any prosecutions. Otherwise, the basic with respect to accident investigation, inspection, those things still lies ahead. Special powers, again, in a factory there is prohibitory clause under the OSH code. Earlier, under section 40, you had a provision wherein the inspector could prohibit any of the equipment or building in respect of hazards. They could have prohibited, and there was no time limit for it. He could have prohibited for any number of days or in a continuous period. Now, under the OSH code, it is mandatory that whenever the prohibition is given by the inspector cum facilitator, it is valid only for 3 days. So, if at all it has to be continued, then it has to be continued by the chief inspector cum facilitator. So, that provision is made under the OSH code. Again, dock work, you can prohibit dock work at any dangerous location. Again, here he can prohibit for continuous period, provided he has to give the intimation or endorsement to the chief inspector. And again, there is an appeal provision within 15 days of issue of that notice. He can come on an appeal to the chief inspector cum facilitator. Under construction work, again, the prohibition can be done by the inspector cum facilitator. Again, he has to endorse a copy to the chief inspector. Also, the provision of appeal is available to every BOCW establishment to appeal to the chief inspector. Again, once an appeal comes, the appeal will have to be disposed within 60 days from the date on which appeal has been brought out. Factories with respect to hazardous process, there is compulsory disclosure, otherwise also was there. Now, on-site emergency plan and disaster control measures, this was already there under 41, section 41B4 of the Factories Act. Now it is at section 84.4 of OSH code. It is mandatory for any hazardous factory. Maintain accurate health record. He has to maintain. That was mandatory under the earlier act also. Medical examination for workers, pre-medical as well as in a period not exceeding 12 months. This was also under the maximum permissible limits of exposure of chemicals will have to be notified by the state government. Workers' right to warn earlier also was there. Now with respect to any hazard, you can directly bring it to the attention of the management and to the factory inspector cum facilitator. Then emergency standards, again, you have central government may direct DG Fastly to lay down emergency standards with respect to hazardous processes that again will come under the OSH code. Now you have hazardous process which was listed in first schedule under the Factories Act, which stood at 29 as of now. Now it has been extended to 30. So there are additions with respect to printing and dyeing on fabrics. Process involving radium or radioactive substance, stone crushing industry, extraction of oil and raw from scrap tire, that is pyrolysis, cigarette manufacturing industry, shipbreaking, hazardous waste and e-processing, semiconductor, styrene manufacturing, nanoparticle manufacturing, then manufacturing processing of mercury or compounds of mercury, lead, tetraethyl, all these things have been come in. So the number of hazardous process industries is going up. Accident reporting, it is a common one. So accident will have to be reported within, if there is an accident, preventing a worker to come back within 48 hours, within the next 24 hours, he has to give intimation that in respect of a factory or BOCW or plantation, this has to be given. And in case it is an accident causing death in a plantation or establishment relating to BOCW, then the officer to whom the notice is given will have to conduct his inquiry within 2 months from the date of receipt of the notice. And in respect of dangerous occurrence or diseases, it is common. The same thing under the Factories Act has been carried forward. The third schedule remains. The only difference here is if any qualified medical practitioner, if any doctor sees into a person and comes across any of the occupational diseases, he has to immediately report it to the chief inspector cum facilitator. If he doesn't do, then he is punishable with a penalty which may extend to 10,000 rupees. Again, special provisions for employment of women. All the prohibitions under the Factories Act, which was there earlier, has been taken off. One was night working has been taken off. Second is there were few processes wherein women couldn't have been employed, like lead processing, these kind of things. Now everything is taken off. Now all establishment can employ women worker in all type of work. They can be employed before 6 a.m. and 7 p.m. Subject to conditions which will be laid down under in the rules by the state government with respect to safety, holiday and working hours with respect to women. Then audiovisual worker, no employment without written agreement. There has to be an agreement to employ anybody as an audiovisual worker. And producer of audiovisual films will have to be responsible for all the welfare facilities to audiovisual workers. And industrial premises for BD and cigar now will be licensed for 5 years at a time. Penalties and punishments. Earlier it was general contravention of the code is section 94, which says it is punishable with a fine which may not be less than 2 lakh, which may extend to 3 lakh. Earlier this was 1 year, 1 lakh or 2 years imprisonment or both. Now it is minimum is 2 lakhs, maximum is 3 lakhs plus 2,000 rupees per day for every continuation of offence for each of the day. Obstruction to inspector, imprisonment up to 3 months or fine up to 1 lakh or both. And repeat offence, it is imprisonment up to 6 months or 2 lakh, whichever is put by the court. Again, non-maintenance of registers. The minimum fine is 50,000 rupees, maximum is 1 lakh. Repeat offence, it is minimum 50,000, maximum is 2 lakhs. Contravention of provision of employment restrictions, it is 50,000 to 1 lakh. falsification of record, it is imprisonment up to 3 months or fine up to 1 lakh or both. Repeat offense up to 6 months or 2 lakh rupees. Then omission to furnish plans, reports or returns, it is minimum fine is 1 lakh, maximum is 2 lakh. Again, for hazardous process, it is imprisonment up to 2 years, fine up to 5 lakhs or plus 25,000 rupees for each day of continuing offense, and maximum if the same offense is continued within a year, then it is 3 years imprisonment or the fine can be up to 20 lakh rupees. Now earlier this imprisonment was 7 years. So now that has been reduced to 2 years, and the maximum amount of fine was 3 lakh, that has been enhanced to 20 lakh rupees. Accident causing death due to contraventions, then imprisonment up to 2 years or fine which is not less than 5 lakh rupees. Serious bodily injury up to 1 year imprisonment or minimum fine of 2 lakh rupees, maximum of 4 lakh rupees. And in both the cases, 50% of the fine will have to go to the family of the deceased in case of death or in case of injury to the injured person. So that means to say, in case of a fatal accident, minimum fine will have to be 5 lakh, out of which 2.5 will have to be paid to the family of the deceased. In case of accident causing serious injuries, minimum fine is 2 lakhs and 50% will have to go to the family, the injured. Working in contravention of section 38, that is nothing but prohibitory order. If at all inspector has issued a prohibitory order that has been violated, then it can be imprisonment up to 2 years plus fine, which may not be less than 2 lakh rupees, may extend up to 5 lakh rupees. Failure to appoint a mine manager, not applicable here, but imprisonment up to 3 months, fine up to 1 lakh rupees or both. Offences by employees, again the workers can also be charged for not using or misusing the safety appliance provided. Earlier this fine was at 500 rupees, now it has been extended to 10,000 rupees. Again, prosecution compounding, as I said, all the cases need not have to go to court now. Now, if at all we file a case under the OSH code, the employer will have a provision to shift the responsibility on others, giving 3 days notice to the court and then bring the actual offender before the court. That can be still done. Then opportunity to comply, inspector must give employer 30 days notice to comply before initiating prosecution. So this is nothing but improvement notice, but this is not applicable in cases of accidents or repeat violations within 3 years of previous punishment. Then limitation of offense. Earlier, if at all there is an accident or any sort of violation observed, the case should have been filed within 3 months from the date of noticing it. Now that period has been extended to 6 months. Jurisdiction of court, it is still either CMM or JMFC court or above. You cannot go to a trial court which is below that, and there is no jurisdiction for any of the civil suits. You cannot go on a civil complaint to any of the courts under the code. Compounding of offense, again, if the punishment is only with a fine, then the minimum fine will be 50% of the fine will have to be paid as penalty. Then compounding can be done. That means to say, in case you don't maintain a register, now you have the maximum fine as 1 lakh, minimum is 50 lakh. So it says 50% of the maximum fine. So minimum fine will be of compounding will be 50,000 rupees in respect of non-maintenance of a register. And in case it is an offence which is a criminal offence which deals with imprisonment as well as fine, then it will be 75% of the maximum fine allocated will be the compounding amount. So this can be done at the department level itself. Department will have officers who are inquiry officers, and inquiry officers can compound an offence at any point of time, and whatever the amount which is collected through compounding will go into a fund called the Social Security Fund, which is established under section 115 of the Social Security Code. So this fund will be funded by that, and that amount will be utilized for the welfare of unorganized workers. And schedule, as I said, first schedule is list of 40 industries which are hazardous. Second schedule, as again, it has OSH standards which deals with around 73 matters for which rules can be framed by central government. Again, third schedule is on the list of notifiable diseases and occupational diseases. Provisions, again, there are few miscellaneous provisions, which is common license for a contractor. As I said, it can be taken from Government of India. The effect of code over agreements, if you have any agreement which overrides provision of the code, are not to be enforced. Inquiry into accidents, again, apart from what state government does, even central government or appropriate government can also formulate or form a committee to look into the accidents or inquiries. Exemptions, again, the central government can exempt any kind of industry or startups from the applicability of OSH code for a brief period for any of the reasons noted in the notification. Again, in case of pandemic or public emergency, again, limiting to a period up to 1 year, the central government can halt the applicability of this code to any of the industry or across the nation. General restriction on disclosure under the code. No officer can disclose any of the matter which has come to his knowledge during the course of inspection or while making an application. Whatever has been submitted, there is a bar on giving it to third party unless a permission is taken from the employer with respect to disclosure of this thing. Again, bar on civil court. No civil court can take any complaint under this with respect to any of the provisions under the code. So the key takeaways on this is, one is it calls for a single unified code replacing 13 labor laws. So again, it is digital first approach. So you'll have single registration and licensing, which will be done. Again, strong worker protection are enumerated under that with respect to written appointment letters, defined wages, 8 hours work days, annual leave, welfare facilities and safety committees. Enhanced focus on hazardous industries. They have, compulsory disclosure of information, emergency plans and health records, and strict liability with respect to, the punishments. Then interstate migrant workers gain legal recognition with respect to they can register themselves, giving self-declaration, as well as they also benefit benefit of portability of either maybe PDS or construction cess. And balanced enforcement. The inspector will have an authority as well as he'll act as a facilitator rather than being an inspector. Serious penalty for persons violation. The maximum penalty has been increased to 20 lakh rupees or 3 years maximum imprisonment has been continued under the process. This is just a list of what OSH code is. And but as I said, if you have to read into the provisions, earlier you had the Factories Act and the Payment of Wages Act. Now you will have to read into 5 books. One is your basic OSH code. Second is the central rule under the OSH code. Third one is the state rule under the OSH code. Fourth one is the rules for the welfare provisions, which is under section 23 and 24 of the code. And then again, you have the occupational safety and health standards, which again will be done by Government of India, which is under section 18 of the code, which already runs to around 573 pages. That's what Manjunath said, that it is, a broad one. It covers almost every manufacturing, every process and every, category into picture, but still we are in the process of finalizing the rules. So the rules are not finalized yet, still open for, suggestions and, objections. So that we are receiving and then we will be finalizing it. Post state rule finalization, we will be waiting for the central rule finalization as well as OSH standard finalization. Then we proceed with that. Okay. Thank you for a nice kind hearing. And any questions, I would request you to note down, and then in the last session, we have a panel discussion with all the panelists who are going to give you sessions today. We will deliberate on that. Thank you.